The next item of business is the Criminal Law, Civil and Defence Miscellaneous Provisions Bill 2026. Motion to instruct the committee. Minister Jim O'Callaghan.
Thank you very much,
motion.
And I move that Standing Order 194 is modified in accordance with Standing Order 241, subsection 2, to provide that it be an instruction to the committee to which the Criminal Law, Civil Law and Defence Miscellaneous Provisions Bill 2026 may be recommitted in respect of certain amendments that it has the power to make amendments to the bill which are outside the scope of the existing subject matter of the bill, in order to A. make amendments to the International Criminal Court Act 2006 in order to give effect to the ratification by the state of the 2010, 2017 and 2019 amendments to the International Criminal Court Act 2006 in order to give effect to the ratification by the state of the 2010, 2017 and 2019 amendments to Article 8 of the Rome Statute of the International Criminal Court, which extends the specific acts that may constitute war crimes to include intentionally using starvation of civilians as a method of warfare in a non-international armed conflict and the use of certain weapons, and also to clarify the legal obligations of Ireland to cooperate with the International Criminal Court with respect to requests concerning all offences under the Court's jurisdiction, and further to enable the Government by order to designate any future amendments or additions to the crimes contained in the Rome Statute as crimes in respect of which Ireland can provide cooperation to the Court, and also to provide for an application-based scheme to enable the disregard of certain historical convictions and other determinations relating to consensual homosexual activity, and to change the title of the bill and make other consequential amendments required to take account of the changes above. Can I just say in my opening remarks at committee stage on this bill, I indicated my intention to bring these amendments at report stage. I'll firstly speak on the proposed amendments to the International Criminal Court Act. These amendments give effect to Ireland's intended ratification of the amendments to Article 8 of the Rome Statute, and also ensure that there is an unambiguous basis for Ireland's full cooperation with the ICC in respect of all crimes within the Court's jurisdiction, including those that are not offences in Irish law. The amendments have three objectives: to ensure that the definition of war crime in the 2006 Act is aligned with Ireland's proposed ratification of the amendments to Article 8. This will have the effect that the offence in Irish law of committing a war crime is expanded to include the use of microbial or other biological agents or toxins, the use of weapons whose primary effect is to injure by fragments which in the human body escape detection by X-ray, and the use of laser weapons. Additionally, the offence in Irish law of committing a war crime in a non-international armed conflict will be expanded to include the following acts that already come within the definition of a war crime when committed in an international armed conflict: the use of poisoned weapons, the use of asphyxiating poisonous gas, the use of bullets which expand, and intentionally using starvation of civilians as a method of warfare. Expanding the domestic definition of war crimes in this way will enable the state to give full effect to the principle of complementarity. This principle obliges state parties to exercise jurisdiction over crimes committed in their territory or by their nationals, so that the ICC is used only as a court of last resort. The second objective of these amendments is to take account of the Kampala Amendment on the crime of aggression. The third objective is to make it wholly clear and unambiguous that Ireland's cooperation with the ICC is not to be confined to those crimes that are domestic offences pursuant to Section 9, subsection 1 of the 2006 Act, namely genocide, a crime against humanity, a war crime or an ancillary offence, but that such cooperation also extends to other offences within the jurisdiction of the ICC, in particular the crime of aggression or offences against the administration of justice by the court. Bringing this legislative clarity will ensure there is no impediment to Ireland fulfilling its obligations under the Rome Statute to cooperate with the ICC. Finally, it is also proposed to add into the Act an order-making power allowing the Government to designate any future amendments of the crimes contained in the Rome Statute as crimes in respect of which Ireland can provide cooperation to the ICC. This would not criminalise the offences in Irish law, but would ensure that in a scenario where Ireland may not yet have ratified such an amendment, Ireland would still be able to fulfil its obligations to cooperate with the ICC. I now want to turn to the proposed legislative scheme for the disregard of certain historical convictions and other determinations, those other determinations being formal Garda cautions and probation orders. As I've previously stated, the Victorian-era laws that criminalised consensual sexual activity between men are now widely recognised as a historical injustice driven by ignorance and prejudice. The offences in question were enacted under British rule, but very regrettably continued in force for the first 70 years of the Irish state before finally being abolished in 1993. However, consenting adults who were convicted of such offences still carry the entirely undeserved stain of a criminal record. We cannot rewrite history, but we can try to undo the pain and hardship that those convictions inflicted upon so many men and their families. What our legislature can do is create a basis by which such a conviction can effectively be nullified, so that its recipient is treated in law as if it never happened. Unfortunately, that cannot be achieved by the expedient of a blanket disregard. That's because the offences in question, and hence the recorded convictions, made no distinction between consensual and non-consensual acts, nor between adults and minors. Any given case must therefore be assessed on its merits by reference to information provided by the applicant and whatever records are available. In that context, a multi-stakeholder working group reported in 2023 with detailed recommendations on an application-based scheme for the disregard of such convictions. The proposals now before this House have been carefully crafted to align, as far as practicable, with those recommendations, whilst ensuring that the scheme is legally and procedurally robust and that it's efficient and accessible for those who wish to apply. These proposals are being put forward as a new part of the bill set out across 14 sections, which variously provide for the offences within the scope, the criteria for a disregard and who may apply, including where the person who received the conviction is now dead, the appointment of an independent person to consider applications and make recommendations to me as Minister, the main processes involved in considering and determining applications and issuing successful applicants with certificates of disregard, the legal effects of a disregard, which are comprehensive, the procedures by which a disregard can be refused or, where it's found to be necessary, revoked, and provisions for the independent review of a refusal or revocation where requested by the applicant. I'm confident that these proposals provide a workable, equitable and accessible means by which those who were unfairly criminalised can finally seek the removal of this unwarranted blemish on their good name. They and their loved ones have waited a long time for a disregard mechanism, and we now have an opportunity to pass it into law in a matter of weeks. I hope I can count on the support of the House for achieving this objective. And just at this outset, I want to recognise the very significant contributions made by Deputy O'Snuddig and Deputy Nash, and indeed other deputies who put forward their own legislation previously, and certainly their advocacy on this issue was a major catalyst and influence on me in terms of trying to ensure we can get this law enacted promptly. So in conclusion, while the amendments to the International Criminal Court Act and to provide for a disregard scheme are obviously completely different from each other thematically, what they have in common is that they've each been a long time coming and are time sensitive in their own ways. Both are also appropriate for inclusion in a miscellaneous criminal law bill currently before the House, and I think this legal instrument offers the most expedient route to get them on the statute book and into force, and that's why I commend the motion to the House.
Deputy Carthy.
At the outset, I just want to put on the record that the way in which the Minister has handled this entire piece of legislation is in no way satisfactory. Not even talking about the guillotine that's in place later on this evening. This is actually the second motion that we've had to the House in terms of motion to instruct the committee, where the Minister has added new, completely unrelated matters to a bill which already covered a range of unrelated matters. Even the title of the bill has changed since we discussed it at second stage. And effectively what that means, and where the concern is that there are matters within this bill that have not been and will not be properly scrutinised by the Dáil, not as part of the pre-legislative scrutiny process, not as part of the Justice Committee's examination of the bill. I want to appeal to you, Minister, not to have a repeat of this situation. Stop the guillotining, stop the rushing, actually allow proper Dáil scrutiny of legislation. This debate focuses on the inclusion of provisions for the disregard of historical convictions for homosexual activity, and then measures to give effect to amendments to the Rome Statute clarifying Ireland's obligation to cooperate with the International Criminal Court. I doubt if there will be an opposition voice against either, and therefore it is regrettable that it has been brought in a manner which in itself, in my view, is controversial. But on the issue of disregard of certain historical convictions, I want to take this opportunity to commend my party colleague, Angus O'Snuddig, along with those from across the opposition benches who have brought forward a bill to provide for this. It would have made absolutely more sense for the Minister to work with his opposition colleagues in facilitating that bill rather than introducing these provisions at this late stage in its Dáil consideration. And aside from that, I want to say that this issue should actually have been dealt with decades ago. Although homosexuality between consenting men was eventually decriminalised in 1993, there was actually little acknowledgement of the profound harm inflicted on generations of men who were convicted in the years prior to this. In the 10 years alone leading up to the decriminalisation, the state had commenced criminal proceedings in 309 cases that resulted in 94 convictions. It's amazing that in our lifetimes people were being convicted for their sexuality. For decades as well, it has to be said that gay men in Ireland lived under a repressive system that criminalised their identities and then fostered widespread fear, isolation and persecution. We know that many gay Irish men felt that they had no choice but to emigrate. Others felt that they had no choice but to keep their sexual orientation a secret, sometimes for their whole lives. I think at moments like this we have to acknowledge what must have been profound hardship of people who were forced to live a life for their entire lives. Criminalisation had a real and devastating consequence for many people. During the AIDS crisis, we know that there was a stigma attached to homosexuality that meant that little public support, often open hostility. And we know that in June 2018, the government issued a formal apology acknowledging that laws criminalising homosexuality were discriminatory and violated human dignity and caused significant harm to those affected. We've moved on, Minister. This is a welcome move. It should have happened long before, but there are different ways that it should have been brought forward.
Is true, mar dúirt mo cholaki nach raibh sé also có rive seo agus nach raibh an dulcin cín déanta gí seo. I welcome this piece of legislation, or this piece of legislation. It's not the way to do it. It should have been a standalone bill. It's such a substantial piece of legislation is welcome, of course, but we're not going to get the proper time to tease through all of the implications of the bits that are missing from it, and hopefully maybe at Senate stage you will be able to address some of the shortfalls or some of the omissions that have been pointed to already by the LGBT Restorative Justice Campaign, who have raised issues, and there are, I believe, simple technical issues that can be addressed, and hopefully I'll get a time when we're discussing amendments that we'll be able to point to some of those. But this is about correcting a wrong that this state presided over, albeit all it did was continue a tradition of the British, where the abominable crime deserved a penal servitude for life or death as a felon, or because of, according to them, outrages of decencies. There's no exact figures of the amount of people who were convicted of the offences during their reign in this state. But there are some figures would suggest that there was up to 1,000, maybe more, from the 1920s up to 1993. But there's probably thousands more, because when people were charged, some of them jumped bail, some of them evaded the courts, some of them were acquitted, but the stigma was attached to them. Others got cases dropped because they had funds, or because of the scandal associated. Others died of suicide in that period. So they're the type of people, hopefully the families of those loved ones, because a lot of them have passed at this stage, or have well passed, will be able to apply for the disregard, and hopefully the independent person will be able to make quick adjudications, and will have the access, because the range of files that will be needed, I don't think is complete in what's there. The Mental Health Commission, for instance, I think control all of the papers from Portrane and places like that. And some of the people who are charged were put into what they called at the time lunatic asylums, and maybe that's where the paperwork is to be found. So maybe we can, between this and the Shannon side, look at making sure that those who will be able to be who are being required to give records will be broad enough to make sure that if there's an eventuality that there's no restriction, or there's no way that any state organ can refuse or block any such access to records.
Deputy Gary Gannon, you're sharing time.
I'm going to take 2 minutes first. Minister, I want to just take 2 minutes just to welcome the disregard amendments. I was delighted to sign the cross-party opposition bill with Deputy O'Sullivan and others on behalf of Social Democrats to advance this issue. It's also an issue I campaigned on before my election to the Dáil. So really welcome these amendments, and thank you, Minister, for bringing them forward. It shouldn't have taken the state 33 years to get to this point. It should have happened much sooner. We do welcome that it's happened. As I said previously, lives will be destroyed by these arrests and these convictions. So many men across generations have been impacted, and I've no doubt in particular those who lived through the 80s and the HIV/AIDS crisis were particularly impacted, and more should have been done for those people. And I want to just take a minute just to highlight some of the concerns raised by the LGBT Restorative Justice campaign, in particular the omissions on the military law. The 2022 Working Group report recommended including relevant offences under military law, and that was a group set up by the former Minister, Helen McEntee, and I think those issues should have been addressed and one to consider. And similarly, Minister, omissions of convictions prior to establishment of the state, I think should have been included as well. There's also limited provisions here related to how people can apply. Relatives and friends can apply. In particular, those provisions are too limited. Many of us within the LGBT community call our friends our chosen family, and they should be able to apply as well. So I do welcome the awareness campaign. I think that's a crucially important part of it. It does need to be go right around the world. Global matrix people left. But there is a real opportunity here, Minister, to remove the legal scars caused by criminalisation. But this is just one step. This is just one thing. For true restorative justice, we need so much more, Minister. We need trans healthcare, closing gaps in family law, banning conversion practices, updating equality laws. And those of us campaigning and marching in Dublin Pride in a couple of weeks' time will be sending that message that we need more, much more to be done on this.
Good morning, Laskin Corley, and I want to begin by acknowledging the work across the Chamber, in particular my own colleague Paul Croyce for the work he's done in this area. Laskin Corley, I want to start by saying the provisions relating to the disregard of historical convictions are not only welcome, they are overdue. It is sometimes easy to talk about progress as though it is inevitable, as though Ireland simply arrived at a more equal place by accident. But the reality is that those rights are hard fought for. They were won by great determination, by hurt, by harm, and by those who chose to believe in better. It is not some distant chapter of history that homosexuality was criminalised in this country. It is within living memory. There are people alive today who grew up in a state that told them there was something wrong with who they were. People who carried not only the stigma of discrimination, but in some cases the weight of criminal conviction for consensual relationships that was wrong. And where the state has done wrong, the state has a responsibility to put that right. At a time when we have seen attacks on LGBTQ communities re-emerge across the world, at a time when there are still countries where people face imprisonment simply for being gay, it is important that Ireland continues to move in the opposite direction. And it is fitting that we are discussing these measures during Pride Month. Because Pride continues to be hugely important recognition of those who came before us, a recognition of the harm that was done, and a recognition that equality is not something that can ever be taken for granted. These provisions matter because they acknowledge a simple truth. People should not spend the rest of their lives carrying the consequences of laws that should have never existed in the first place. For that reason, we will be supporting this important provision. There are aspects of it that were particularly welcome. The inclusion of those convicted as juveniles is important. We know that some young people were caught up in a system that not only criminalised them, but in some cases led them into institutions where the consequences followed them for years afterwards. The recognition of discriminatory policing is also significant. For many gay men, it was not simply the law itself that caused harm, but the way in which those laws were enforced. Practices of entrapment and targeted policing ruined lives and careers and left many carrying a burden that lasted decades. That recognition that many people were forced to leave this country to escape persecution are also welcome. We should never forget that for many Irish people, immigration was not a choice made in pursuit of opportunity, but an escape from a society that refused to accept them for who they were. But while we welcome the scheme overall, there are still some issues that deserve further consideration. I am concerned that former members of the Defence Forces who may have been dishonourably discharged or otherwise penalised under parallel military provisions do not appear to be fully covered. The proposed timeframes may also be too restrictive. We know that from every other historical injustice this state is attempted to address, that trauma does not operate in a dull timetable. It can take years for people who feel ready to come forward. That challenge will be even greater for those now living abroad. These are not reasons to oppose the scheme, far from it. These are reasons to continue to improve it, Minister. And if this legislation proceeds quickly to the Shannon, as appears likely, I hope there will be an opportunity to examine some of those issues further. And while I welcome the substance of those revisions, I have to say that the process by which multiple complex policies have been added to this legislation at the last minute is deeply frustrating. Because once again, we are looking at a bill that has become a vehicle for pretty much everything that the Minister has chosen to add into it without scrutiny. It deals with community sanctions. It deals with the use of incapacitant spray in prisons. It deals with counselling records and rape trials. It deals with firearms legislation. It deals with defence force powers. It deals with European arrest warrants. It now deals with international criminal law and historical convictions. Many of those issues deserve attention. Many deserve reform. But every single one of them deserves proper scrutiny. Take the issue of counselling notes and sexual offence trials. We are talking about legislation that will affect survivors of rape and sexual violence. Legislation that goes to the heart of privacy, dignity and access to counselling, fair trial rights and administration of justice. This is one of the most sensitive areas of criminal law this House has legislated for. The same can be said for the Defence Force provisions inserted into this bill. Hugely significant new statutory powers around state security and aid to civil power have been added into a miscellaneous provisions bill. Powers that warrant detailed examinations, detailed question and detailed debate. Yet here they sit alongside a huge range of unrelated matters, all bundled together under one legislative umbrella. And that is a problem. If legislation affects the most vulnerable rights of citizens, it affects the victims of crime, it affects civil liberties, it affects state powers exercise, then it deserves the time and attention required to get it right. Instead, we are increasingly seen to be treating miscellaneous provisions bill like legislative suitcases into which anything can be packed so long as there is room. The public cannot properly follow what is happening, civil society groups can't properly engage, and members are expected to navigate a growing list of complex and unrelated issues within the exact same piece of legislation. The irony is that some of the most important legislation we pass in this House is often the legislation that receives the least focused attention because it arrives bundled together with so many other measures. So while I'm delighted to see provisions related to historical convictions, and I support ensuring that Irish law keeps pace with developments in international criminal law, I do not think it is unreasonable to ask why all of these issues are being dealt with in this way. Important legislation, Minister, deserves scrutiny, and legislation that will impact lives in the most profound ways should not be rushed, bundled together and pushed through as part of an ever-expanding miscellaneous provisions bill. Minister, this is starting to look like a tactic. It really is. I mean, all of us have an important role in this House in terms of scrutinising legislation, making amendments, engaging with groups who have been impacted, hearing from civil society groups, getting into committees, being deliberate, focused in our work. But this is the guillotine. This is an 8-minute speech. Shortly afterwards, we'll have a guillotine that falls after 90 minutes. That is no way of doing legislation. It undermines this House. We've seen it before with the International Protection Bill, and we're back here again. It's a poor way of doing legislation. It's a poor way of treating Parliament.
Deputy Alan Kelly.
Thank you very much, Cathaoirleach. Just want to commence, Minister, by saying that I've got 20 years service as I suppose, a national public representative. But in here, this is the most mental bill I've ever dealt with. It is crazy. It's just lots of good stuff in it, lots of really good stuff in it. But as regards the structure of a bill, it is beyond comprehension. It gives the miscellaneous bill a new meaning. It is so diverse. It is not good practice. It is the worst kind of practice. In fact, it is the worst way. I can nearly guarantee you that there are going to be issues out of this legislation because it hasn't been scrutinised to the level required. And I know time is of the essence of some of these. I respect that. I know there is pressure in relation, and particularly from opposition, in relation to a range of things. For instance, the disregard has been brought in today, which we 100% support. But this is no way to do it. Like, the list of stuff going through this bill is like an A to Z of everything in the department. It's crazy stuff. And other departments, and the Department of Defence, and the Department of, like, a who's who of, like, so obviously we're doing the ICC Act and the disregard of homosexual offences today. Arrest warrants issued in relation to prisons, your capacity to ask for defence for help, counselling notes, sex for rent, DNA, pepper spray, community service orders, face coverings. Like, there's so much. That's, yeah. But like, if you were sitting here from a few years ago, Minister, you'd be saying what I'm saying. There's no doubt you would. Oh no, I remember quite clearly your criticism of the previous Minister for Justice, who you now sit beside. I remember it quite clearly in relation to lots of legislation. I have to be honest about this. This is no way to do legislation. Like, for instance, the issue in relation to the disregard, that's such an important topic on its own. The issues in relation to the ICC Act and the Rome Statute, that's critically important. It has domino potential impacts in relation to the triple lock discussion, which I will point out in a second. And also, Minister, I mean, from an actual administration of democracy and for us to do our jobs in here, it's borderline impossible because of the manner in which this is constructed, the cross-references, from a legislative point of view, the drafting, the manner in which we have to approach it, the volume of legislation covered, everything. Even versioning, I'd say, is a problem, particularly in relation to this bill. So, Minister, in relation to the disregard of historical offences for those from same-sex relationships, I just wanted tonight to acknowledge all the work that has been done by many different people down through the years. I've named them inside here previously, and I am delighted that this issue has been dealt with by you and you've honoured that commitment. But I also want to acknowledge over a decade's work by my colleague here, Jed Nash, who has literally been in your ear about it since you became Minister. And it's very rare you get to say it about the person sitting beside you. But as a colleague who I've known for many years, he has continuously been on about this for well over a decade. So I just want to acknowledge that while he's here tonight. A second issue, Minister, is in relation to the ICC Act and the Rome Statute. And I just want to reference part of this. So, and particularly the issue of the 4 components in relation to the act of aggression. Okay? Where there is an act of aggression by a state, the crime requires that the act, by its character, gravity and scale, constitutes a manifest violation of the Charter of the United Nations. Not every unlawful use of force would give rise to a manifest Charter violation. However, since the ICC has never prosecuted anything previously, or hasn't been prosecuted previously, there is a possibility here, basically, on unintended consequences if you get rid of the triple lock. And that's what I'm going to try and warn you about here tonight, Minister.
Deputy Nash.
Thanks very much, Minister. I very much appreciate your acknowledgement earlier on in your opening contribution that the legislation I produced 9 years ago now was, in essence, the catalyst for the disregards propositions before us this evening. We know that for the bulk of the history of this state, we made criminals of men, of gay men, because of who they were, because of who they loved. And for many of those who we didn't criminalise, they received public order records, they received cautions and so on, imposed on them by an uncaring state at a very different time in our history. And the bill that I presented back in 2017 referred to the need for exonerations of men who had criminal records for having sexual relations that are no longer under offences under the law. And the first part of my bill, you'll recall, Minister, called for a formal state apology for the wrongs this state and our society perpetrated by our laws and our actions on the LGBT+ community. And I was very proud that, arising from that legislation, the then government agreed to issue a formal state apology in both houses of the Oireachtas in the summer of 2018, marking the 25th anniversary of decriminalisation. And tonight is a milestone, it's a landmark, and I want to pay tribute to people like Kieran Rose, Carl Hayden, who's with us here this evening, Eddie McGuinness, Brian Sheehan, other members of the Disregards Restorative Justice, the LGBT Restorative Justice Campaign, successive ministers, by the way, Ministers Flanagan, McEntee, yourself and others, your officials as well, for the contribution that they've made to getting us to this point. My only regret, Minister, is that the time given to this bill by government isn't in any way in accordance with the significance of what we are doing here tonight, and that's regrettable and something I hope that you will reflect on. And I do hope that the gaps in the legislation between what the working group recommended, what Labour's position is, I've spoken to you about this, where those gaps are, where those issues are, that sufficient time will be provided in the Seanad, when the Seanad is dealing with committee stage and report stage amendments, to finesse and nuance this legislation. It is of such historical significance that I believe you should give that its due recognition and the time it deserves to be debated properly and nuanced and finessed.
Deputy Lawless, 4 minutes.
First of all, Minister, there are some positive things in the bill. There are some things that I would very much like to vote for, and there are difficulties with the bill as well. But it is very broad and it is very, very diverse, and I do think it would have been much more positive if we had the opportunity to engage with them on an individual level and discuss them in detail. We support the proposal around the counselling notes, Minister. People who have suffered, particularly from sexual assault, should not have their private counselling notes spilled out over a courtroom. And the reforms in relation to that, I believe, is a step in the right direction. There are some major concerns, Minister, and those relate to the community service aspect of the bill. One part of this legislation, I believe, and it's quite clearly outlined, that it will allow potentially drug dealers who in some cases would have been considered for a 2-year prison sentence to basically get community service. And we oppose that wholeheartedly. It's very clear, Minister, that I think the objective here is primarily to do with the prison capacity more than actually safety for society or indeed anything else. The solution here is basically a community service order because of the fact that the prisons are so overcrowded. In 2024, over 1,000 prisoners were released on temporary release within 24 hours of being sent to prison. The previous Minister, Helen McEntee, told Aintu following a parliamentary question that her officials were selecting candidates for early release due to capacity issues in the prison. And that is deeply concerning, Minister, that is happening. And I do think that we need to have a serious conversation, and you need to ensure that the prison capacity is expanded significantly. So pieces of legislation like this are not necessary. And certainly I think that basically the idea that community service is being used now as a tool to try to alleviate the capacity difficulties in the prison should concern us all. In 2024, 700 prisoners were went missing from the system. By the end of that year, 131 prisoners unlawfully at large were still unaccounted for. And the fact that currently 66% of prisoners in Ireland are repeat offenders is very worrying as well. And the system is crumbling, and people are being released within a day in some cases of incarceration is simply not good enough. And in relation to prison capacity and in relation to such an alarmingly high reoffending rate, prison capacity does have an impact on that. Prison capacity does impact the ability of programmes and so on that can, that should be taking place, and in some cases cannot be because of the difficulties in the prison service. This is obviously totally unacceptable.
Just here in the nick of time. So I welcome the opportunity to speak on this legislation. As others said, it's a mishmash and probably worse for that fact. I just want to focus in relation to the section dealing with access to counselling records in sexual offence trials. Last week, Beyond Surviving conducted a focused consultation with survivors, 52 individuals who engaged between the 6th and 9th of June. And these are people who would know the realities, the harsh realities of the courtroom, and who understand the consequences when legislation is drafted in a way that doesn't actually respect their needs and their wishes. So the message, I suppose, from the survivors is that the bill is welcome, but it doesn't give them the full protection. So Section 13 strengthens the existing framework by requiring that all applications for council records must go before a judge. So that's welcome. It's a shift away from informal or administrative disclosures. So survivors recognise this as a necessary safeguard. And amendments that introduce a presumption of non-disclosure and create a form of statutory privilege and extend protections to other sensitive records, such as medical or child protection files. They're important steps. And again, it does take cognizance of the fact that the counselling notes are very kind of intimate information given in a context that doesn't have a court in mind, and the reflections of trauma, and they're supposed to help people heal from that trauma rather than prepare them for a court date. So I welcome some moves in that respect, and as do the survivors. And the bill reinforces that the justification clause for disclosure, so there would be some form of judicial oversight. But the survivors also pointed out, and I was contacted by some of them, and that's why I'm emphasising them in particular, because I know the bill covers a whole lot of other areas in terms of historic convictions, Department of Defence, etc., etc. But the one thing I want to emphasise again, as others have said, is that the stated intention, the presumption of non-disclosure, doesn't appear in the actual text as far as I could see. So basically, if you don't have the law operating as intended, it's not going to work. You have to have an explicit presumption, not an implied one. And second, the bill doesn't set out what they would say is a clear statutory test in terms of relevance, necessity, proportionality, in the way that ensures consistency in practice and in case law. Survivors told me about the failures of Section 19A, how vague drafting allowed broad, intrusive requests. And they're saying, as one put it, quote unquote, the drafting needs to be precise. The failures of 19A cannot be repeated. And the bill also gives survivors no agency in decisions about their own counselling notes. They have no right to be heard. It's their notes and their life being discussed at one, yet they have absolutely no input. So the waiver should stay in place as it provides autonomy. So that loss of control isn't addressed. So there are a couple of the points they've raised, and I hope they'll be taken on board, Minister.
That's Concorda. Minister, like the other speakers today, it's a huge technical challenge trying to put together the overall meaning behind each section of the bill, because by its very nature it's a miscellaneous bill. And while you have the benefit of your own advisors in the department and the expertise of the Department of Justice, I'm no doubt, as a former opposition spokesperson in Justice, you have sympathy with the rest of us who have to try and put it together. Look, the one thing I would say is that we were all here at a previous stage, and notwithstanding changes that have been made, very significant elements of this bill were already before us, as complex as they were then and as they are now. I look forward to maybe coming in on some of the 72 debates that are 72 amendments that are ahead of us. But let's not fool ourselves. The reason why there's pressure to put this bill through is not because the Minister wants to put it through, because many of the issues in this bill are things that members of the public and groups that have worked very hard and campaigned on are calling for. And I just want to also acknowledge the work of Deputy Nash in regard to the historical convictions. And I think in this House we often wonder whether we achieve anything at all. And I think maybe on days like this, people like Jed can take note that work that he undertook has reached completion. But it's for that very reason that I say that sometimes facilitating bills in this way is really important, because it's about getting stuff across the line as well. And so I take on board the comments made by members of the opposition. I had that issue in the last phase of this bill, but I have done a little bit of homework since, Minister. There's a lot in this bill that I think is to be commended. And I would say there's one area that I significantly have been waiting on some time myself, and that is the work of the Apartment Owners Network under the guidance of Pat Montague, who've been seeking the transfer of responsibility for multi-unit developments and the legislation and regulation of that over to the Department of Housing. That's incredibly important, because we're about to pour millions and millions of euro into an apartment defect scheme. The people with responsibility for spending and delivering that are private entities private limited companies in the form of owner management companies. We need to have a way to make sure that we regulate those companies, and we can't do that while the responsibility currently sits with the Department of Justice and has to be transferred over to the Housing Agency. That's one of the many things that this bill does, and we're waiting desperately for it to happen. So, Minister, I do understand the concerns raised by opposition, but I would underline the point that the provisions in this bill are needed and required, and that is why I'm glad to see them before the House, and that's why I'm glad to see them that they will be enacted as well.
Minister.
Yeah, thanks very much, Caroline, and I want to thank all deputies for their contributions. I'm not a very philosophical person, but one thing I do know, Caroline, is that ministerial careers come and go very, very quickly. And as Deputy McAuliffe said, but I'm well aware of it, and I hope individuals in this House have the great privilege to be ministers at some stage in the future. But it comes and goes, and officials, with the greatest respect, are outstanding people, but they will be there for many years. And if you want to get something done as a politician, you have to push it through. I know people are at one level criticising me because this bill contains a whole variety of different issues. It does. But the reason I've tried to squash as many issues into this bill as possible, because I want to get these provisions enacted for the benefit of people such as men in Ireland who were convicted of homosexual offences prior to decriminalisation. In fact, it was Deputy O'Snuddig and Deputy Nash, when they raised it with me in my earlier days as a minister, and they said that we wanted this done. I went back to the department and I recognised that the quickest way to get it done was to put it into a miscellaneous provisions bill. Like, with the greatest respect, had I not done that, had I not put it into the miscellaneous provisions bill, we wouldn't even be near pre-legislative scrutiny at this stage. And we have the report that's sitting there, and one of the criticisms that's regularly made is that, oh, you're not getting things done, you're sitting on things, as you're perfectly all entitled and obliged to say to me if things aren't being done. So I'm not going to, I know you're not asking me to, but I'm not going to apologise for trying to get important measures that are of benefit to the public enacted as quickly as possible. And I think we all agree that the disregard scheme is something, as everyone has said, it should have been done decades ago. And I wasn't going to allow a situation develop where I found myself maybe in the third year of being a Minister for Justice and wondering, will I get it over the line? So I have driven it and I want to get it done. And I appreciate, by the way, all the contributions that members in this House make. It is not the case that you haven't scrutinised, you haven't given me your views on these issues. In many respects, I've been listening to you for the length of time that I've been Minister, and I hear you all the time in terms of saying what you want to get done. Can I just deal with some of the other issues that were raised? And I think the most important thing that was raised in respect of the disregard scheme was the issue about military law. I think Deputy Rice raised it, and I think Deputy Nash raised it as well. Can I just say, in the course of consultation on the drafting of this, there were significant legal concerns about including any case in which a person was court-martialled for military misconduct. And on careful consideration, I concluded that these offences could not appropriately be included, and there were two principal difficulties. First, it would be legally questionable, but also impracticable, to attempt to determine whether a particular court-martial was brought purely because of the homosexual nature of an act, rather than because it involved a disciplinary infraction, such as abuse of rank, which would equally have been the case had the act been heterosexual in nature. And second, the relevant misconduct offences under the 1954 Act remain in force and, according to the Department of Defence, continue to be used today. Their inclusion would open the possibility of misconduct convictions right up to the present day and into the future being relitigated under a scheme intended to address a historical injustice. Equally, to impose a cut-off date such as the 1993 decriminalisation would almost certainly be challenged as arbitrary and unfair, and for those reasons to consider that the conclusion of these offences would not be legally or operationally viable. However, military convictions for the repealed offences of buggery, attempted buggery, gross indecency and importuning are within the scope of the scheme. Second point of a principle that was raised, I think it was by Deputy Rice again, was that what about including convictions prior to the establishment of the state? This country, this government has no responsibility for acts that were done prior to the declaration of the Irish Republic and our independence. I cannot go back historically and start operating a disregard scheme because of the criminal justice system that operated in Ireland under the Crown. And I applied that in respect of the granting of pardons as well. It's a different country. This republic is not responsible for what happened prior to our independence. So listen, I very much welcome the discussion on this. I know there's a lot in the bill, but like everyone in this House wants to get these provisions enacted, not for the benefit of deputies or ministers or anyone else, but for the benefit of members of the public who all need to see this legislation enacted.
So that concludes the debate. I must now put the question that the motion be agreed to. Those in favour say tall. Those against say nil. Consider the question is carried. So we now move to the report on final stages of the Criminal Law, Civil Law and Defence Miscellaneous Provision Bill 26. And we'll deal with the amendments. Okay.
I'm going to do it first of all with Amendments 1, 21 and 32. I think I move Amendment 1. As I say, it's grouped with Amendments 21 and 32. Amendment 1 amends the long title to include a reference to the Criminal Justice Act 2006. Amendment 21 is a technical amendment of subsection 1b of section 16 to substitute a reference to the singular subsection with a reference to the plural subsections. Amendment 32 is a technical amendment to section 18 to substitute a reference to section 38(1) and section 45 with a reference to sections 38(1) and 45.
So the question is that the amendment be made. Is that agreed? Agreed. Amendment is agreed. So we'll go to amendment number 2 then. It's a recommittal is necessary in respect to this amendment and the other related amendments as they do not arise from committee proceedings and relate to the instruction to the committee motion. So 2, 33 to 45 inclusive and 72 are related and will be discussed together.
Thank you very much, Cahirlock. I move Amendment 2. I'm pleased to introduce these amendments which propose a motion to recommittal. It's agreed.
That's right. Agreed.
Count Corla, I'm pleased to introduce these amendments which propose a number of technical amendments to the International Criminal Court Act 2006 to give necessary effect to Ireland's intended ratification of the amendments to Article 8 of the Rome Statute. The main objective of these amendments is to amend the International Criminal Court Act 2006 in order to make clear that war crimes within the meaning of the Act includes Article 8 of the Rome Statute. Expanding the domestic definition of war crimes in this way will enable the state to give full effect to the principle of complementarity that I spoke about earlier on. These amendments will also provide a legislative basis to ensure Ireland can fully cooperate with the ICC in respect of all crimes. Amendment 2 inserts new text into the long title of the bill. Amendment 36 is a standard definition that defines the International Criminal Court Act 2006 as the Act 2006. Amendments 33 and 35 are consequential on that. Amendment 37 inserts some new terms for definition in the interpretation provision in Section 2 of the 2006 Act. First, the definition of the Rome Statute is updated. Second, it defines the term crime of aggression. Third, it defines the term crime within the jurisdiction of the International Criminal Court. Fourth, in order to future-proof the extent of Ireland's ability to cooperate with the ICC, a new order-making power is inserted as a new Section 64A in the 2006 Act. Finally, it inserts a new subsection 1A to clarify that the term crime within the jurisdiction of the International Criminal Court includes an act for which criminal responsibility is provided for by Articles 25, 26, 27 of the Rome Statute. Amendment 38 inserts an additional subsection into Section 6 of the 2006 Act to clarify that where following the commencement of the section a relevant amendment has been adopted with respect to Articles 6, 7, 8 of the Rome Statute, any reference to an article of the Rome Statute in section 6 should be construed without having regard to that relevant amendment. Amendment 39 replaces subsection 1 of section 8 of the 2006 Act with a new subsection clarifying that, in addition to applying to genocide, crimes against humanity and war crimes, ancillary offences under the 2006 Act shall apply with respect to offences against the administration of justice, but not with respect to the crime of aggression. A new subsection 1A will also be inserted in section 8 to clarify that, for the purposes of subsection 1, account shall not be taken of any future relevant amendments that may be adopted to articles of the Rome Statute. Amendment 40 ensures that no retroactive effect is given to the new domestic offences created by the amendments to the definition of the Rome Statute. Amendment 41 clarifies that when the state exercises extraterritorial jurisdiction over war crimes, the reference to Article 8.2 of the Rome Statute shall not be construed as that article as amended by a relevant amendment. Amendment 42 clarifies that the Minister for Justice, Home Affairs and Migration shall be able to request the ICC to provide assistance with a domestic investigation or prosecution of an offence against the administration of justice, in addition to ICC offences or other serious offences. Amendment 43 inserts a new section 64A into the 2006 Act in order to confer an order-making power whereby, should future amendments be adopted by the state parties to the Rome Statute definition of genocide, a war crime, a crime against humanity or the crime of aggression, an act specified in that amendment may be prescribed by the government on my request, having consulted with the Minister for Foreign Affairs. So they are the amendments until we come to Amendment 44, which makes a number of technical amendments to sections 4, 19, 22, 31, 37, 38, 50, 50A, 51, 52, 53 and 63 of the 2006 Act. Amendments 45 and 72 insert an additional Schedule 1A into the 2006 Act. Part 1 of the schedule was set out the 3 sets of amendments to Article 8.2b and Article 8.2e of the Rome Statute concerning war crimes committed in international and non-international armed conflicts, respectively, adopted in 2010, 2017 and 2019. Part 2 will set out the amendments to the Rome Statute, providing for the exercise of jurisdiction over the crime of aggression.
Just for the record, the Minister proposed early move for recommittal, and I'm taking it that was agreed. Just have the record straight.
That's great. Yeah.
This was the first question. So we now move to the amendments, and the question is that the amendments be made.
Agreed.
Agreed. So those in favour say aye. Against say nil. The amendments are made. So pursuant to Standing Order 1943, it is reported to the Dáil that the long title has been amended. Now move to Amendment 3 in the name of the Minister. And again, recommittal is necessary in respect of this amendment and other related amendments, as they do not arise from committee proceedings and relate to the instruction to committee motion. And ask the Minister to move recommittal.
Yeah, I move recommittal.
Yeah, the amendment 3, 8, 12, 46 and 51 to 64 inclusive are related and will be discussed together.
Yeah, thanks
so
very
if you
much.
would move the recommittal.
I move. I move specifically now Amendment 3, having moved the recommittal.
Yes.
Great. The amendments I'm now moving in this group, last count Corda, are amendments in respect of the disregard scheme. And as you said, Amendment 3 is grouped with Amendments 8, 12, 46 and 51 to 64. These amendments collectively provide for an application-based scheme to enable the disregard of certain historical convictions and other determinations relating to consensual homosexual activity. The other determinations in question are formal Garda cautions given in lieu of prosecution and probation orders given in lieu of conviction. The substantive amendments providing for the scheme are Amendments 51 to 64, which collectively insert a new Part 14 into the bill, comprising 14 sections. Amendment 51 inserts an interpretation section for the new Part 14. It includes the key definition of relevant conviction or other determination, which includes convictions in a criminal or military court for the offences of buggery, attempted buggery, gross indecency and importuning. It also defines the categories of persons that come within the definition of an immediate family member and that of a relative. This is relevant for the purposes of applications that may be made on behalf of deceased people. Amendment 52 inserts a new section which sets out the criteria that are to apply to the granting of a disregard application. Those criteria, of course, include that the relevant person did not cause any other person to participate in the sexual activity without their consent. Amendment 53 inserts a new section setting out certain key provisions in relation to the making of an application. This includes provision that a disregard application may be made by a relevant person, namely the person who incurred the conviction, or by someone nominated by the relevant person to make the application on his behalf. It also provides that where the relevant person is deceased, a disregard application may be made by an immediate family member, or if no immediate family member can or wishes to make an application, by a relative, provided there is no objection from an immediate family member. Amendment 54 inserts a new section providing for the appointment of suitably qualified or experienced independent persons to consider applications and independent reviewers to carry out reviews in case where the Minister proposes to refuse an application and the applicant seeks such a review. Amendment 55 inserts a new section providing for a preliminary assessment of an application by the independent person in order to satisfy himself or herself as to whether the applicant is the relevant person or is otherwise eligible to make an application on behalf of a deceased person. Where the independent person is not satisfied, the same provision is made that he or she shall not consider the application further and shall notify the applicant and the Minister accordingly. Amendment 56 inserts a new section providing for the substantive consideration of the application by the independent person and the subsequent making of a recommendation to the Minister as to whether the independent person is satisfied that the conviction should be disregarded. The section includes a provision that any public body which may hold records relevant to the application shall provide those records to the independent person on request. Amendment 57 inserts a new section providing that the Minister shall consider the independent person's recommendation and either issue a certificate of disregard or else notify the applicant that the Minister is not satisfied that the conviction should be disregarded. The section provides that where a disregard certificate is issued, the Minister shall notify all relevant public bodies and that they shall annotate any relevant records they may hold in order to clearly reflect the disregard. Amendment 58 inserts a new section setting out the general effect of a certificate of disregard. The section effectively provides that the relevant person shall, to all intents and purposes, henceforth be treated as if the conviction never occurred, and that there are no circumstances in which the disregarded conviction shall be disclosable other than where the relevant person chooses to disclose it. Amendment 59 inserts a new section to provide that an applicant may seek an independent review of the matter, either where the Minister has proposed to refuse a disregard or where the independent person is not satisfied that the applicant is a person eligible to make the application. In either case, the application shall be examined afresh by an independent reviewer other than the person who originally considered the application, and a recommendation submitted to the Minister as to whether or not to reaffirm the decision in either case. Amendment 60 inserts a new section to deal with a scenario where, subsequent to issuing a disregard, the Minister receives information giving rise to the reasonable belief that the application included or was supported by false or misleading information, and the Minister is longer satisfied that the conviction should be the subject of a certificate of disregard. The section provides that the Minister shall in any such case notify the applicant that the Minister intends to revoke the disregard, and that the applicant may seek a review which shall be carried out by a retired judge of the Circuit Court, High Court or Court of Appeal appointed by the Minister. Amendment 61 inserts a new section to provide that where the Minister proceeds to revoke a disregard, he or she shall notify the applicant and also the relevant public bodies, who shall be required to reannotate their records to reflect the revocation. Amendment 62 inserts a new section to provide that the Minister shall make appropriate efforts, including a public information campaign, to raise awareness, particularly among relevant persons in the state and beyond, of the disregard scheme and the effects of a disregard. Amendment 63 inserts a new section containing a number of provisions relating to the protection of personal data under the scheme. This includes provision for the redaction of any non-relevant convictions held by a relevant person if alive, or any information that could identify any other living person in connection with any offence. Amendment 64 inserts a new section to provide that nothing in this part shall create any new rights or any cause of action nor impose any liability on any person or on the state This is provided for the avoidance of doubt. Finally, there are a number of technical consequential amendments as follows. Amendment 3 amends the long title of the bill to take account of this new part, while Amendments 8, 12 and 46 each amend a number of definitions and references to enactments elsewhere in the bill to take account of related references introduced by this new part, while Amendments 8, 12 and 46 each amend a number of definitions and references to enactments elsewhere in the bill to take account of related references introduced by the new part. Thank you very much, Chair.
Question is that the amendments be made. Sorry, Deputy Sully.
This is basically the time where we get some discussion on the content of the amendments, and as we said earlier, we've welcomed the disregard scheme that is announced, and we welcome also those members of the LGBT disregard campaign who are in the audience here, and thank them for all their hard work, and the other deputies who thankfully, as you admitted yourself, put pressure on you, and you put pressure on the officials, and we are where we are. And we have it before us. And as I said in my contribution, hopefully between now and the Shannon State, if there is small little technical issues, because there always is with pieces of legislation, especially historical ones, and there was a question about why we're not going pre-1922. There have been pardons given by the President in that of years, and why 22? Why wasn't it 1937 in the Constitution? Why not 1948 when the executive authority was 1916, 1867, or if you want to go back to the First Republic, is 1626. So it's something you will have to answer yourself, or I will keep raising it. But I think in the main, the value of this is for families who have in living memory people, loved ones who have passed, who had the small, if you want, of the shadow of convictions upon them, who are affected. Those who are alive still, because there was still people before the courts well into the 80s and into the early 90s, and the fact that you were before the courts meant that that hung around like a bad smell on you, affected all your work. And also, one of the bodies, the public bodies, which may have information is for instance, adoption. If you sought adoption of a child, you would be refused because you have a conviction. So maybe that's one of the bodies. And as I said, the mental health institution, the Department of Education were also always very scrupulous about digging out people and throwing them out if they were anyway suspect in their eyes. So there is the question of the records, employment records of people, and whether they're kept. And I don't know whether it's DPAR or whomever, because it is in one of the provisions here that the consideration of its public bodies, where the Minister, as soon as practical, notify or cause to be notified for each public body, and that's not just the public bodies that are mentioned; it could be other public bodies. So it's to ensure that there is, if you want, in the private sector, in social media, there is the right to be forgotten. And one of the problems with some of this is the names, addresses in some cases, and the convictions are available online if you search newspapers and that. And it's not necessarily, we're not going to look for it today, but it's something to look to see whether it's an equivalent right to be forgotten if people had that disregard, that they could approach the social media companies, kind of the newspapers or whoever, so that they could blank out those, so they don't come up in a search. I think is the method that's used in the right to forgotten. That was brought in to protect people who have small convictions or kind of low convictions, to ensure that it wasn't held against them when they went for employment or other type of vetting processes. So, as I said, it is welcome. Court documents will be key in this. In many ways, because when I did the research, and there was only a cursory research on convictions, the newspapers carried very little specific detail, and you're right in terms of making kind of the distinctions have to be made, and sometimes they didn't make the full distinction of the background of whatever case. The churches as well is another case in point. Kind of, they would have records of people, and the suicides is another kind of record. So I don't know. I think kind of if you can stick to the timetable that's set out, kind of up to two months, kind of for the records to come back from any department in this country is kind of very interesting if you manage to do that. Well, not you, but the independent assessor, and then within two months of that, making the judgment. I would welcome that. It's a high bar you've set yourself, and the access to National Archives, and the other main one was kind of the records that the military service have as well. There are records there. There were people who kind of, they weren't necessarily court-martialed, but they were cashiered out of the Defence Forces rather than be charged, and so they would have those records, and those records are in personnel files. And again, this isn't to add a burden; it's just to make sure that kind of, and it might be just a provision at the end of the list of the public bodies is and any other public body that the independent assessor deems fit. I don't know whether that would cover it, just in case there are incidents, because it might be people in the Coast Guard, and it might be people in other services. I'm not an expert kind of on all of this, because, as I said, when you research, kind of the research is quite close. But it's welcome that we are trying to close a very dark chapter in our history.
A few brief comments, Minister. The issue in relation to the pre-22 convictions is obviously differential to what the working group said, which is a pity, and obviously the previous speaker has spoken about military archives as well, so how we can deal with that. The other issue, it relates to the working group proposed a dedicated independent body as the first contact, model on the IHREC. You know, obviously, this is the first time we're getting this component of the legislation put into this Act. We won't go back and talk about that again, but was that something you considered, or does everything have to go through, is being transmitted through the Department of Justice and yourself? Everything is being basically routed one way, and do you think that's the best way of doing it? It's you know, if that's going to be your style as regards everything, that's fine. It's just you know, in many other scenarios they would have gone through some form of independent process to cross-check and review everything one step away. Ministers usually like to be one step away, but in fairness to you, in this case, we're right in there. But having no first point of contact body with the support and advocacy, it's more the advocacy part of it that I'm getting on about, because you know, there'll be a lot of emotion in relation to this as well in many cases, and no standing panel of assessors. The working group also proposed a hierarchical but flexible approach in relation to representatives for deceased people. I suppose the query relates to the structure that's there for immediate family members, you know, including cohabitants and partners having the priority. But if nobody immediate is willing to put forward the case for somebody, can somebody who is a close friend or somebody who, is there any process, because there is going to be circumstances like that, given the nature of what we are discussing, is there any potential pathway for somebody to act on behalf of somebody who's deceased, but to honour their wish, if there was a wish for this to be dealt with? In relation to the working group also devoted a dedicated chapter to formal statements as the mechanism for cases where records no longer exist or are insufficient, and amid specific recommendations in House Just statements should be sought and assessed. But the bill doesn't contain an equivalent provision, so there's no express mechanism for disregarding a conviction where no records can be found. Independent persons may seek information from public bodies, but there's no formal statement procedure as a substitute. So where a person or persons would make a formal statement, but there isn't the records, and there can be reasons why records can't be found, which you've spoken about yourself before in relation to other things. So is there a process where you could consider that formal statements or statements could constitute a submission to this? And maybe you might look at that in the Shannon, Minister, because I think it's probably the most important point I'm going to make here as regards any amendments to this. The review process that you've proposed in relation to 28-day timeline is fine, and then but it is different from what the review said as well. A couple of the last points. The working group recommended that the state apology of 2018 be reiterated on launch of the scheme, and that individualised letters of apology from the Minister be provided to successful applicants. That's not in the bill. Is that something that you would consider? It's quite an emotional issue, so I think it would be very nice. It's not a must-do, but it would be a nice thing to do, I think, in fairness, given the topic we're talking about. And they also recommended a fixed time limit for making applications. The bill imposes a 24-month limitation period, but I have read there that you have discretion to extend that, so that's probably okay. So they're my honest contribution, Minister. There may be a couple of issues there, particularly in relation to where statements could be made in support where there isn't documentation available. You might consider that. Thank you.
Thank you, Deputy. Deputy Gary Gannon, please.
Minister, I'll keep it brief because I don't want to reiterate points that have already been made. Minister, I suppose you might be able to answer me. Are you still open to making amendments to at the Shannon stage in terms of improving some aspects of the bill? You are. Thank you, Minister.
Okay, very good. Minister to respond.
I want to thank deputies for their contribution. Can I just start with Deputy O'Snuddig? And like him and other deputies, I should also commend people who aren't members of the Oireachtas, but who really led this campaign to see this injustice righted. In particular, Carl Hayden, Kieran Rose. I just want to commend them and acknowledge the excellent work that they did. Deputy O'Snuddig and Deputy Kelly both referred to why doesn't it apply to convictions prior to 1922. As I said to Deputy O'Snuddig earlier on, I have a very strong view that this state does not have responsibility for convictions that were imposed when Ireland was a colony of the United Kingdom. We were not autonomous in exercising and operating our own criminal justice system, and consequently, I think it would be dishonest and inappropriate for us to go back and say we have a responsibility for what happened prior to the declaration of the Irish Republic. And I suppose really 1922 is the year that is picked, because that is the time when, in effect, notwithstanding the earlier declaration of the Republic, that Irish people became responsible for their own affairs and we operated our own criminal justice system. And, that's the reason I made the policy decision earlier and got the approval of government that we would not be going back into the 19th century or the 18th century and issuing pardons to people for whom we have no liability for what happened to them. Like Tone and Emmett were convicted of high treason. Are we going to say that we in some way are responsible for their convictions and that consequently we could pardon them? I don't think so. Deputy O'Snuddig also mentioned about the court documents. Court documents are going to be extremely important, and I just wanted to agree with him in respect to that. Deputy Kelly spoke about the pre-22 convictions, I've already answered. He spoke about there not being an independent body, but it's going through the Department of Justice. Obviously, there are independent people who will be appointed reviewers, but I think this is the most efficient way to get it operating and acted out and achieving the objective as quickly as possible. I don't want to set up some separate statutory agency that has glossy reports and takes a year to get up and running and has PR. You know, we just want to get this thing done, and this is the best mechanism to do it, and there is an independent process in respect of it. I agree with Deputy Kelly about advocacy being very important. That's why we'll be advertising this scheme, and I know everyone in this House will cooperate in terms of making people aware of it. Deputy Kelly also spoke about would I give consideration to an apology, repeating the apology of 2018. I will consider that, and I will listen to what deputies have to say and people outside. Although I have to say, if you keep repeating an apology, it sometimes lessens the significance of the original apology. And I just thought that apology in 2018 was very significant, and I don't want to take away from it. And then, as Deputy Gannon asked, am I open to considering amendments? Of course I am. In the
just one escapist. Do you accept if there's no record?
Oh yeah. Like, listen, it could be the case that there are no records, and but like the scheme is flexible enough to permit statements. And also, sorry, another thing you mentioned was about the friend. Like, there's a very broad definition of relative, which is contained in the scheme in section 42, and obviously this is going to apply in respect of a deceased person. But listen, there are mechanisms whereby it could be considered. The person may have nominated a person who isn't irrelevant, who isn't a relative, to make the application on their behalf after they're deceased. But like, there are going to be necessarily legislation discriminates. You identify a group of people that you want to try to benefit. There may be hard cases at the edges. I'll give consideration to that in advance of the Shannon. But the primary purpose of the bill, I think, is sound in terms of the ability of particularly people who are living to make an application, and also for persons who are nominated by them to make an application on their behalf, or the relative definition, which extends to, it's a very broad definition of relative. It includes grandnephews, grandnieces and others involved. And that's why it's important to make people aware of this scheme, because there are people who may not be aware that they have a great uncle or who was convicted, and they could bring the application.
Sir, Deputy Gary Gannon, please.
And to come back in, but you said something I profoundly disagree with on the idea of having the cut off at 1922, because the state shouldn't be responsible for what happened when we were a colony. I mean, you began your contributions earlier on by talking about how you inherited this system from the UK, and it's not like we radically transformed the system right afterwards. What we did was maintained and actually enforced and became part of it. So, I mean, the idea that actually we have a cut-off line because we can't be responsible for what happened when we were a colony, when we simply didn't deviate one iota from when we weren't. I mean, in terms of how we treated people, you just said yourself that we inherited the system, but we also maintained. But we maintained the system. So a person who was imprisoned in 1921 for homosexual offences at the time would still have been in prison in 1922, 23 potentially. So, Minister, we become custodians of our own history. We can't just pull a line. If you're not going to apologise, we can find a means by which we honour, acknowledge, respect, and say, actually, we do come complicit, because it wasn't like we changed tact. By your very nature, we had this system right up to 1993. So I think we could actually find a way of acknowledging. I appreciate we can't do something that happened when we were a colony, but we can also acknowledge, honour, but the fact that we did not deviate when we weren't straight afterwards.
Okay, so the question is that the amendment be made. Is that agreed? Agreed. Okay. So pursuant to Standing Order 194.3, it is reported to the Dáil that the long title has now been amended. We move on then to Amendment number 4 in the name of the Minister. This arises out of committee. 4, 7 and 69 are related and will now be discussed together. Minister O'Callaghan, please.
Thanks very much, Cathaoirleach. I move Amendment 4 and it's grouped, as you know, with Amendments 7 and 69. Amendment 69 inserts a new section into the bill to amend Schedule 5 to the Social Welfare Consolidation Act 2005 to add the court service to the schedule. This will mean that the court service will be a specified body for the purposes of specified provisions of the 2005 Act relating to the personal public service number, and thereby enabled to use the PPSN where permitted in accordance with the 2005 Act. Section 20 of the 2020 Miscellaneous Provisions Act, which provides an enabling basis for the transmission of documents and information by electronic means to and from courts and civil proceedings, envisaged the use of the PPSN to verify the identity of persons so transmitting documents and information by electronic means. This is also envisaged in court rules made pursuant to Section 20. However, the 2005 Act was not consequentially amended by the 2020 Act to add the court service to Schedule 5. This amendment addresses that gap and means that the identity of relevant court users can be authenticated via the PPSN as envisaged by the 2020 Act. Amendment 4 amends the long title consequential on the insertion of the new amendment. Amendment 7 amends subsection 4 of subsection 1 of the bill to provide the amendment to the 2005 Act, along with the amendment of the Defence Act 1954 in Part 4 of the bill, introduced at committee stage, will be commenced on enactment rather than by ministerial order. And I want to flag that I'm considering further commencement of the bill generally, and that subject to this consideration, I may introduce amendments in the Seanad to enable other provisions in the bill to commence on enactment rather than by ministerial order.
Minister, Deputy Pat Daly, please.
For this opportunity, just in relation to the family law section, I just want to raise one issue which is there, Minister, and at the outset I want to say that I was the beneficiary of being on the criminal legal aid scheme for a number of years, for many years, and the concerns have been expressed by people who are on the scheme, and there's, as you know, Minister, there's a flat fee payment coming in from the 1st of July, and you will only be paid at the very, very end of the when the case finishes in court. So if you appear once or if you appear 20 times, you will only get paid at the very, very end of it. So there are scenarios, particularly for vulnerable people, for children, for people who have not English as a first language, and their cases go on, and sometimes 12, 15, 20 times, and they will only get paid the once. And we saw with the family law courts that in Kerry, for example, there's only 3 or 4 solicitors left on the scheme after the introduction of a flat fee. So I'd ask you to maybe consider if you appear more than 5 or 6 times, to review that, because you could have a scenario where someone represents someone 8 or 9 times or even 10 times. They change solicitor, the client changes the solicitor for another time, and it would be potentially one person, that solicitor could get paid for one appearance, and the person who has been there for 8 or 9 times doesn't get paid at all. So it's just that there will be runnings and learnings from it, but from the family law courts, just learn that the amount of people representing has gone down, and just like in family law, where it's important that people receive representation, that there's access to justice, the same with criminal law cases. Thank you.
Okay, Minister, to respond.
I think, in fairness to Deputy Daly, it would be a bit rich of me if I objected him to raising a matter that's outside the scope of the bill, since the bill is so broad in any event. But I hear what you say. The scheme is designed, that's been brought in from the 1st of July, is designed to improve efficiencies in the criminal legal aid scheme in the District Court. I fully appreciate the important role played by solicitors under that scheme. I've met with the Law Society in respect of it. I've met with the Bar Council in respect of it. I think the system will be greatly improved, and there's still going to be proper payment for solicitors in terms of the very significant work that is done in the District Court. But I'll take into account what you said, Deputy.
Thanks, Minister. Deputy Gary Gannon.
are you making the assumption that the scheme would be improved? Because, I mean, nobody else seems to believe it, but yourself, the Law Society doesn't believe it, the Bar Council doesn't believe it. I haven't seen any research that points to it. In fact, what the evidence of those in the system would say is actually what's going to happen is we're going to have to develop another two-tier criminal system where those who can afford to pay will actually get better treatment, and because the system is no longer not only profitable but like realistically workable, that you're going to be losing people from the criminal justice system.
Conscious we've a lot of amendments to get through, and I'm happy if you want to put it down as a topical issue, I'm happy to come in, Deputy Gannon. But can I say this, the scheme as it operates at present is that you get €260 for the first appearance and then €60 for every appearance after that. And like that just incentivises inefficiencies, and I've research completed within the department that shows that a hearing of criminal cases in the district court, which are governed by the criminal legal aid scheme, move much slower than those which don't have the benefit of the criminal legal aid scheme. And also there are a number of anomalies in terms of, as I'm sure you're aware, in terms of certificates being granted for a whole series of offences in respect to the same person, or indeed for a whole group of defendants who are effectively accused of the same type of offences out of the same issue. It needs to be reformed, I can assure you, but I'm happy to come back and discuss it with you if you want to put it down as a topical issue.
The question is that the amendment be made. Is that agreed?
Agreed.
Agreed. Okay. So amendment number 5 in the name of the Minister. This arises out of committee proceedings. 5, 6, 7 and 71 are all related and will be discussed together. So Minister, will you please move the amendment, please?
Yeah, I move Amendment 5, and as you say, Caherlick, it's grouped with Amendments 6, 70 and 71. Amendments 70 and 71 are small technical amendments to both the Family Courts Act 2024 and the Miscellaneous Provisions Act 23 that are necessary ahead of the standing up of the first family courts next year. The amendments are to fix a legislative lacuna that will otherwise arise when certain provisions of the Family Courts Act 24 are commenced. Commencement of Section 5 of the 24 Act will repeal provisions of certain enactments, including Sections 40 and 40A of the Civil Liability in Courts Act 2004, which provides for the in-camera rule and proceedings under relevant enactments as defined in Section 39 of the Act. Included in relevant enactments is Section 37 of the Criminal Justice Miscellaneous Provisions Act 2023, which provides for the in-camera rule to apply to court proceedings under Sections 28 to 30 of that Act, which in turn relate to applications for civil orders where there is the fear of violence or where serious alarm of distress is being caused by a person's behaviour. When commenced, Sections 96 and 97 of the 24 Act will replace the repeal provisions, and relevant enactments will be defined in Sections 95 of the 24 Act. However, Section 37 of the 23 Act has not been defined as a relevant enactment for the purposes of the 2024 Act, and that's why it is therefore necessary to make these technical but important amendments to fix this lacuna. Amendments 5 and 6 amend the long title consequential on the insertion of the new sections to amend the 23 Miscellaneous Provisions Act and the 24 Family Courts Act.
Okay, so the question is that the amendment be made. Is that agreed? Agreed. Okay. Amendment number 6, in the name of the Minister, arises out of committee proceedings already discussed with number 5. The question is that the amendment be made. Is that agreed? Agreed. Amendment number 7 arises out of committee proceedings brought by the Minister, already discussed with number 4. The question is that the amendment be made. Is that agreed? Agreed. Amendment number 8, in the name of the Minister, arises out of recommittal proceedings, already has been discussed with amendment number 3. The question is that the amendment be made. Is that agreed? Amendment number 9, in the name of Deputy Alan Kelly, arises out of committee proceedings. It was agreed. Number 8. Amendment 8 was agreed. Amendment number 9, in the name of Deputy Alan Kelly, arises out of committee proceedings. Deputy Kelly. You please move your amendment.
I move.
Yeah.
Minister, we spoke about this previously, and you said you were going to look at it, and so I gave you time to look at it. I didn't see anything coming forward again in relation to this. So, Minister, what we're trying to do here is ensure that anybody who is going to be intimidated as a member of an Garda Síochána that the process by which there will be an offence created whereby if they are or their family members are intimidated in any way in the performance of their duties, that this will be an offence. We know very well that given what has happened in the recent past in our jurisdiction, the way in which Gardaí have been treated, the way in which their family members have been treated, but in particular the way in which Garda members have been treated. Their houses have been targeted. The GRA at their national conference have referenced this, the manner in which many Garda Síochána going about their daily lives when they're off duty, the intimidation levels have been of such a significance that they are the capacity of them to function as Gardaí, the capacity of them to do their perform as Gardaí is certainly being affected. And you said that as part of this miscellaneous bill, which we've spoken about in such a wide depth, that you would look at this as regards this stage. And I'm wondering, did you look at it? I took on board what you said previously, but I resubmitted the amendment on the basis that you said you would look at it.
I did say that, and I did have a look at it, Deputy Kelly, and I support the intention behind the legislation to ensure that there is legal recognition of the fact that Gardaí deserve to be protected. I suppose my problem was I need to have a broader consideration of the legislative proposal in light of other legislation that is there at present. And, like, if, for instance, one of the things that was brought to my attention, I'm aware of Section 19 of the Public Order Act provides substantive protections for members of An Garda Síochána and other peace officers, such as prison officers and members of the fire brigade, in the execution of their respective duties. And I suppose if I'm going to introduce this provision, like, I'm going to have to think, well, what's the response going to be from, say, those other emergency workers or people who are involved in the prison service or fire brigade? And Section 19(1) of the 1994 Act provides that any person who assaults or threatens to assault a peace officer, including a member of An Garda Síochána, is guilty of an offence. And there are very significant penalties there. On summary conviction, a fine not exceeding £5,000 or a term of imprisonment of 12 months, and on indictment to imprisonment for a term not exceeding 12 years or both, or a fine at the discretion of the court. So, like, I am aware it's an issue. Listen, it's an issue I'm worried about. I can't just put it in now because I need to consider the impact on other workers, other groups. But I will give you a commitment. I will give further consideration to it, and I know that you won't be hesitant about bringing it forward again. Like, it is something I am. It's something I'm aware of, and the mischief is there that people are becoming increasingly aggressive. Some people are becoming increasingly aggressive to An Garda Síochána, notwithstanding the fact that we all know the overwhelming majority of Irish people are very supportive of the Gardaí. But I can't accept it at this stage, Deputy. I'd need to give it more consideration, I'm afraid, but I won't run away from it in the future.
Deputy Alan Kelly.
Okay, thanks, Minister. Look, I'm taking your word for it. I will be pursuing this issue. I honestly believe that we do need to reach another bar when it comes to not just Gardaí, but all uniformed. The intimidation of uniformed personnel in this country, the manner in which they're being treated, the way in which they're being treated off duty, the way in which their families potentially are and their homes are being targeted. We have reached a different threshold in relation to this whole issue in this country, and we do need to deal with it. There needs to be respect. There needs to be, and the people who wear the uniforms obviously need to have respect as well, and the overwhelming majority absolutely do. I'm bringing this forward because I believe there's a necessity for it, and the GRA have asked for it, Minister, as well. And while I have you, Minister, we also need, in conjunction with that, in order to protect An Garda Síochána, also need to bring in new legislation in relation to pursuit and offences for pursuit, where Gardaí are being prosecuted and on their own licences on the basis of pursuits, where in some cases I think that is really wrong. But Minister, on the basis of what you've said, I'll withdraw the amendment, taking on board that in the spirit of what you said, that you will bring forward something. If you don't, I will, and you'll hopefully support it.
Is it agreed that the amendment be withdrawn? Is that agreed? Agreed. Amendment number 10, in the name of Deputy Alan Kelly. This amendment has been deemed out of order. Amendment number 11, in the name of Deputy Alan Kelly, arises out of committee proceedings. Deputy Kelly, will you move this amendment, please?
Minister, this is in relation to the Non-Fatal Offences Against the Person Act 1997, and is amended to incent a provision which relates to every single one of us inside here, and ministers and senators. It's in relation to the obstruction of the free movement of members of the Houses of the Oireachtas. And this is particularly pertinent, again, Minister, because societally we have everything has changed. And there's been numerous cases where people in this House have not been able to go about their business. Now, we all know there is constitutional protections in relation to access to and from Dáil Éireann. But there are also cases whereby members of this House, members of government in recent times, have been restricted in their movements for a period of time because they, unfortunately, the manner in which some people dealt with him was far from what would be acceptable, and An Garda Síochána may not have been available at the time. So this amendment in relation to is making an offence to deliberately and ongoingly obstruct free movement of members of the House of the Oireachtas. A person who by violent means or any form of intimidation or without lawful authority obstructs or impedes the freedom of movement from any place of a member of the House of the Oireachtas is guilty of an offence. Minister, this will also obviously need broader consideration, my guess is what you were saying. But certainly I believe, and my party believes, that we do need to look at, in a broad sense, how we're going to ensure that people who are elected for these houses can go about their business while respecting protest, can go about their business and are not to a level that is unacceptable, being intimidated or unlawfully dealt with or violently threatened in any way, shape or form, which prevents them from going about their business as representatives of the people of this country.
Thank you, Deputy Matt Carty, please.
Yeah, and unfortunately, just because of the way in which the Minister has framed this debate, a 90-minute debate is just not enough, and it's not fair, Minister, because there's lots of amendments already that I think members would have wished to speak for. I just want to put on the record I don't support Deputy Kelly's amendment. Anybody who is preventing others by unlawful means, obstructing them or impeding the freedom of movement should be held accountable before the law, and it shouldn't matter whether the person who's been impeded is a member of the Oireachtas or not. And I don't believe that in a republic you provide particular privileges to members of the Houses. The Constitution has provision that protects the unimpeded access to this House in order to fulfil our constitutional duties. I just think it would send out the wrong signal if the Oireachtas were to pass legislation protecting members of the Houses of the Oireachtas and not others. Going back to my earlier point, Minister, in terms of the time, this debate started 40 minutes earlier. We have only 90 minutes to deal with a wide range. I don't know if it's in order, but can the Minister propose an amendment to the order of business to extend this debate to ensure that particularly the debate that we all want to have on counselling notes will have sufficient time?
Deputy Ruth Coppinger.
Yeah, Cahir, look, I would ask Deputy Kelly to withdraw this because, for a number of reasons, I think we're giving out about things being added on to this bill, and here's another important issue being added on at this stage. I don't agree as much of a nuisance as it is going in and out of this stall on many an occasion, I don't agree that we should curb civil liberties and the right to protest by late at night without proper discussion in this stall introducing something that would remove any form of intimidation, which can be interpreted in lots of ways. And I just would ask you, we're here in a disgraceful, not your fault, but the Minister's fault, situation where there are survivors of sexual and gender-based violence in this stall tonight, who came here, who've been campaigning for a year, who spoke to the Justice Committee. And I was told by the Taoiseach earlier today that they would have their issues heard. He said, we've added on extra time. Added on extra time to other issues, not this issue. Now, there's very important issues here. I'm not blaming any deputy for raising them. But we're going to be in a situation, unless the Minister agrees now to extend this debate, that survivors will leave this chamber with this bill rammed through, without any of their amendments heard, without the Rape Crisis Centre's amendments heard, and lots of other issues. And I think that that is an absolute shame, and it would send a horrifically bad message out about how this government treats the issue of gender-based violence. So I need to jump in at this stage and support the call for the order of business to be changed. This is an absolute disgrace. I've never seen anything like it in the years I was in the Dáil before.
You've made your point. Just we've to try speak to the amendment as well. I do hear what you've said, though. Minister O'Callaghan.
Yeah, thanks very much, Gary. I'm not actually supportive of Deputy Kelly's amendment. I don't find it frequently the case that my access or the access of many colleagues coming into and out of the Houses of the Oireachtas is blocked. I don't recall ever being blocked coming in or coming out. But the purpose of it, I suppose, is to try to say that we don't tolerate intimidation of elected members of the Oireachtas, and I think that is a valid point. It's also important to point out that I'm aware of, say, since October 2022, there's been approximately 10 convictions of people for intimidating or violence against members of the Oireachtas or associated members of the Oireachtas. Like, we all know the case of the Taoiseach, there was a case in respect to the Taoiseach, a case in respect to Deputy MacDonald. So, like, if people start intimidating politicians online, the law is there to meet with them. And if people start to intimidate or harass politicians physically or anyone else, the law is there, and the law is responding to it fairly vigorously. And I think the laws are in place there sufficiently to ensure that that happens. Thanks.
Minister, do you wish to press the amendment? Okay. So you're withdrawing the amendment. Is it agreed that the amendment be withdrawn? Amendment number 11? Agreed?
Yeah.
Agreed. Amendment number 12, in the name of the Minister, arises out of recommittal proceedings, has already been discussed with amendment number 3. Minister, can you please move this amendment?
Move.
Is it agreed that amendment number 3 be made? Is that agreed? Agreed. Amendment number 13, in the names of Deputies Carthy and Ward, arises out of committee proceedings. 13 and 14 are related and will now be discussed together. Can you please move the amendment number 13, please?
I move, and this amendment is to delete lines 25 to 40. Back in April, at the height of what are now called the fuel protests, the Minister himself added fuel to a volatile situation. He called essentially for the Defence Forces to be deployed to assist Gardaí in removing fuel protest blockades. It was a serious escalation and provocation at the time when the government should have actually been focusing, and all ministers, and particularly the Minister for Justice, should have been focusing on de-escalating the protests. Then we had a situation a few weeks later, out of the blue, amendments to essentially expand the deployment of Defence Forces in aid to civil power being brought forward by the Minister for Defence, added to a Minister for Justice. There has been no explanation whatsoever as to what exactly happened to bring this situation about. The Minister for Defence was before the Justice Committee, at committee stage, completely evasive or ignorant, or certainly unable to answer specific questions as to why now and what additionality would be allowed or provided for the Defence Forces that is currently not provided in law. We don't know where the impetus for bringing these changes came from at this time, why they're being done in such a rush manner as part of a miscellaneous bill, which we've already discussed, covers a huge range of unrelated matters. We've been very clear in Sinn Féin. There are issues, particularly the issues with regard to our naval services contained in these measures that we fully support. We support the concept in principle of aid to civil power, but we also believe that there has to be utmost accountability and transparency. And there are serious concerns about what the government and the ministers, Justice and Defence, are bringing forward and why they're doing it in the manner in which they're doing. The provisions on aid to the civil power, they raised serious questions as to whether or not the government are trying to, in an underhand way, amend the law so that it can become common practice for the Defence Forces to be used in terms of the policing of protests. We know that An Garda Síochána is the primary civilian policing authority and that any Defence Forces support has to remain exceptional, time-bound and very tightly controlled. So Amendment 13 that I'm moving proposes deleting the provision of the bill regarding aid to the civil power from this bill. If those powers are needed, well then let's deal with them where they should be dealt with, which is as part of a defence bill where there can be proper scrutiny by the sectoral committee responsible for that and proper analysis as to what exactly government are proposing and why they're proposing it. So let's bring forward and tell the Minister for Defence to bring forward a bill that actually deals with that. Amendment 14 would require an annual report and review of these sections in the event that the government actually refused to accept Amendment 13, which is to actually allow a bit of democratic scrutiny for something that is crucially important. Deals with the policing of protests and many other areas, and there are huge concerns around this provision, but not so much what's in the provision, but why this provision was brought forward in the manner in which it has been.
Minister O'Connell.
I was at the committee hearing as well, as were you, and you got a straight answer from the Minister for Defence when she told you that these proposals were put before government before any fuel protests. So your suggestion that they're trying to be linked to that is completely untenable. I'm going to deal promptly with this because, like others, I want to get to the Counselling Notes Amendment, which is Amendment number 17. So I'm not going to accept Amendment number 13, and I'm not going to accept Amendment number 14. I think it is appropriate that the legislation should make express provision for the long-standing role of the Defence Forces when they assist the Gardaí, and I think that aid to civil power is better off to be set out on a statutory basis.
Okay, Deputy Carty.
Yes, don't be disingenuous, Minister, and talk about wanting to get to the counselling notes issue. You've been asked by two members now to ask the Chief Whip to come in to amend the order of business to give more time. Because I have decided against every instinct in my body not to call a vote on this motion, on this amendment, because I think it is crucially important. And the reason I'm not going to call a vote is because of the people who are in this gallery here and their right to hear this House discuss a matter of utmost importance that has come about as a result of them telling us all their own personal testimony. So I ask you not to be so disingenuous, but I'll tell you what I will be doing. I will be calling a final vote on this bill and I will be voting against it. And one of the primary reasons will be on the basis of not only the manner in which this has been brought forward, but your entire attitude towards this debate and your decision. And it was your decision, Minister, to curtail this entire debate, a myriad of debates with new provisions added at the very last minute to a 90-minute debate.
Okay, pressing the amendment?
Press.
Okay. So the question is that the Amendment 13 be made. Is that agreed to?
Agreed.
Okay. The Chocty Tá Bhabhar Aberdish Tá. The Chocty Iguina Aberdish Neil. In my opinion, the question is lost. Amendment 14 has already been discussed. Can you please press amendment, or please move amendment number 14? Okay. The question is that the amendment be made. Is that agreed?
Not agreed.
Okay. The Chocty Tá Bhabhar Aberdish Tá. The Chocty Tá Iguina Aberdish Neil. My opinion, the question is lost. Amendment number 15 in the names of Deputies Carty and Ward. This arises out of committee proceedings. 15 and 16 are related and will be discussed together. Can you please move the amendment, Deputy Carty, please? Okay. Do you wish to speak? Yeah.
I wish to speak, yeah. And again, I'm going to be very brief on this, Minister, because I want to get to the next section, which is really, really important. But this section itself is hugely important. Amendments 15 and 16, they were proposed by a group of academic researchers and expertise in probation services, and most of them gave their time to the Joint Committee as witnesses. They have experts in community sanctions, judicial attitudes, sentences and use of research and evidence in criminal justice policy. Minister, I know they sent these amendments to yourself. I actually withdrew them at the committee stage because you said you consider bringing something forward yourself. So I'm not going to argue the rest of the case. And I want to just hear: have you considered bringing forward amendments similar to what I have here? And if you haven't, what's the reason for not doing so?
Minister O'Callaghan.
Yeah, I did consider it, Deputy Ward, and my concern is that the proposed amendment is seeking to sort of merge and align community service and probation. As you know, they're both two very different statutory regimes. Probation of Offenders Act deals with a court being able to dispose of a summary offence either by dismissing the charge or discharging the offender conditionally, and obviously community service is something very different. And the way the amendment is drafted, having given it consideration, I thought it was merging those two schemes inappropriately, that they're distinct. But as I identify the objective of what you're doing, and I have no difficulty in terms of in the future trying to work with you on proposals to ensure that we do have schemes in place in respect of community service, community sanctions, and actually you'll know there's a lot of provisions in this bill that deal with that in any event, but I can't accept the amendment.
Deputy Ward.
Yeah, I just think it's ironic that you're talking about merging acts. You have to merge in a whole calamity of issues into one bill here, Minister. Actually, I listened to the last debate that was on previously. You wanted to squash everything in. I'm sure there was a way to get this done. I will be bringing something forward again on this, Minister, in my own time, probably as a PMB.
Are you pressing Amendment 15?
I press.
Okay. The question is that the amendment be made. Is that agreed?
Agreed.
The Choctaw Ivarber Aberdeen Taw. The Choctaw Taw Gwynna Aberdeen Neil. In my opinion, the question is lost. Question 16 has already been discussed with Amendment 15. Could you please move the amendment, Deputy? Okay. The question is that the amendment be made. Is that agreed?
No, agreed.
The Choctaw Taw Ivarber Aberdeen Taw. The Choctaw Taw Gwynna Aberdeen Neil. In my opinion, that question is lost. Moving on to amendment number 17, in the name of Deputy Alan Kelly, arises out of committee proceedings. 17 to 20 inclusive, 22 to 26 inclusive and 65 are all related. 18 to 20 inclusive are physical alternatives to 17. 19 and 20 are physical alternatives to 18. 20 is a physical alternative to 19. 65 is consequential on 20. 17 to 20 inclusive and 22 to 26 inclusive and 65 will all be discussed together. So Deputy Alan Kelly to move Amendment 17, please.
Thank you, Ciara.
Can you move the amendment?
I move the amendment.
Thank you.
Sorry, Chair, can I just ask how much time is left? Sorry,
26 minutes. 26 minutes.
26 minutes.
Okay, thanks.
Thank you, Ciara. This is, I suppose, Minister, we should be spending hours discussing this instead of spending 26 minutes. I'm not going to take up all the time because I have spoken on this at length inside the committee. I am putting forward on behalf of the Labour Party the proposal, which is an amendment that has been drafted by the Dublin Rape Crisis Centre by Lachlan Staines in relation to a compromise to deal with this highly sensitive issue, which our Justice Committee had harrowing and very upsetting and detailed evidence directly to us, and also, I'd say, many of us in that portfolio have had personally as well. I suppose there is a pendulum here, Minister, which we have to deal with the constitutionally of what we're trying to achieve. I respect that. but also dealing with it in a manner in which we can push it as far as we can possibly. And that's what this amendment is trying to do. I suppose the real issue here when it comes to the actual detail is the independent review panel and what is being proposed in the legislation versus the phrase which you have brought in yourself, which changed the pendulum, which is the phrase "in the interest of justice." And I suppose that's where the debate was the last day. And we're back here without any change, so I've resubmitted the amendment. Minister, I think spiritually all of us here, whether we are in government or in opposition, are of the one mind in relation to how we need to deal with this. Counselling notes should not be used. It's as simple as that. And then we as a legislator and us as those participating need to ensure that we deal with this in a manner which does meet constitutional requirements, legal requirements, technical requirements and all of that. So what is proposed, and I'm definitely not going to go through it in the same level as committee, is that panel members will create a narrative and there will be limitations on the information provided as a result through that narrative and so on. And that is the format by which we will deal with counselling notes. And as a consequence of that, victims will not be traumatised and counsellors will be protected. That's what I'm trying to achieve. That's what the Dublin Rape Crisis Centre is trying to achieve. That's what the Labour Party is trying to achieve. That's why we spent so much time supporting this, speaking on this and voting on this at committee stage. And I believe that within your own party and within government, there is I suppose, a spiritual support for doing this. This, we believe, extends to the limitation of what is achievable constitutionally. It will deal with the issue of how counselling notes need to be dealt with. It deals with ensuring that those victims are protected. It meets all the requirements as far as what we need within the limitations of what we know we can do constitutionally. And that's why I've pushed it forward again. Minister, at this late hour, I would ask that you reconsider it, that you look at it again, because ultimately, as I said previously at committee stage, I don't think anybody is going to be happy at the way it is currently drafted by yourselves in government. Even if they walk through and vote for it, I don't think your own government colleagues will even be happy, and certainly in opposition. I am trying to create a compromise and ensure that we have something that we can collectively all support.
When the Justice Committee considered the Criminal Law and Civil Law Bill, the heads of bill, which seems a long time ago, there's lots more heads since, but this was one of the, again with the heads of bill, one of our criticisms was that there was a huge aspects of the bill that we weren't able to spend any time with. The sex for rent provisions, there was a whole load of other areas that we just didn't get to deal with at all, and could only deal with written submissions. But we put quite an amount of discussion on this aspect of the bill, and there was cross-party agreement. Now, you know yourself, when pre-legislative scrutiny reports, Minister, sometimes they get nodded through, or somebody proposes something and people don't realise. This was a considered debate and discussion, and what was agreed by all members of that committee was that there should be complete and unconditional ban on the use of counselling records in sexual offence trials. We all have a responsibility. I feel a particular responsibility as chairperson of that committee to bring forward and to stay true to that position, but also to outline how that decision came to, because crucial to reaching that decision was actually listening to what victims and survivors had to say in both written testimony, and there was quite extensive written testimony, but also in oral evidence from organisations that have first-hand experience. But I have to say, in particular, Hazel Behan, who addressed the committee and made a profound impact on all of us, to the point that the position was agreed. Survivors have strongly asserted, they've told us, that the practice of their counselling notes being used in criminal trials, potentially in defence of the person who attacked them, it causes severe psychological harm and that it heightens suicide risk. That's the evidence we heard. So, of course, and I haven't heard a single person disputing the need to protect a right to a fair trial, we have also got a duty. We have a duty to victims and survivors, and we must ensure that that duty is also put at the heart of how our justice system works. And that includes not subjecting victims or survivors to degrading treatment, which is what this is. It is degrading treatment for somebody to go in and discuss their most personal, intimate details with a professional. And for that professional's notes, however elaborate or otherwise they might be, to then be summoned by the courts, the purveyors of justice in this state, for the use of the defence of the person who was the reason why they needed counselling in the first place. It is absolute lunacy. So banning the disclosure of counselling notes is about recognising that they're hearsay evidence. That's what they are. Absolutely, and it is about rebalancing our justice system. So not only is there a fair trial, but that there is a fair justice system for victims and survivors. The amendment that I have put forward, number 18, provides for a full ban on the disclosure of counselling notes, because that's what's needed. We've discussed it at length. We've heard from victims and survivors. We've heard about the trauma. We've heard about the intimate details. I also just want to speak briefly to Amendment 2024, which is about the removal in the Minister's wording of the phrase "in the interest of justice." And again, we discussed this in quite detail at committee stage. That, above all else, in terms of the amendment to the original bill that the Minister has brought forward, is the cause of concern, because we all know that solicitors and barristers are going to have an absolute field day discussing that term of words. And we know that that term is going to allow some defence attorneys to be able to secure the counselling notes of some victims, and therefore we've brought forward that amendment. And then Amendment 25 is the last case resort, which is ensure, and this is on the advice of Rape Council, Rape Crisis Ireland, that there would be very clearly instruction to any jurors in the event that these type of notes are brought forward, that they would be clearly told that these are hearsay. This is hearsay evidence, and what I would hope in that it would dissuade some defence counsels from seeking them in the first place. But what's actually needed is the full unconditional ban. That's what the Oireachtas Committee that was tasked, that's our job, we're tasked with actually analysing the first place. But what's actually needed is the full unconditional ban. That's what the Oireachtas Committee that was tasked, that's our job, we're tasked with actually analysing the heads of bill and bringing forward recommendations to the Minister. And I just want to put on the record my sincere thanks for those people who have told their stories. I've mentioned this before, because in order to save others from the trauma that they have gone through, they have actually told the world their most intimate details, have gone beyond the counselling room in order to try and make that a safe place for others. And I want to thank all of those, some of them who are in the gallery here, many others who I've had what I would consider to be the privilege of meeting. I also want to acknowledge and recognise Deputy Coppinger's effort throughout all of this. The first time I became aware that this was, and I say this to my shame, but the first time I became aware that this was an issue at all was when Deputy Coppinger brought a private member's bill before this House. And I have to say, it's not too often on a Thursday evening, late evening debates that you're moved by an issue. When I was moved by an issue, the argument to me just appeared unassailable then, and it is still unassailable as far as I am concerned. So, Minister, even at this late stage, I know we have Shannon stages and all the rest of it, but I am imploring on you, find a way to make all of those efforts worthwhile. Find a way to ban what I consider to be a cruel and inhumane practice.
Pardon? 7 minutes, Deputy. How much have we left? Oh, yeah. Excuse me.
Okay, 6. No, because I know there's other people who
15
want to speak.
minutes. There's 2 more deputies if you wish.
Okay. Well, look, just to reiterate again, not to use up my time, but it's disgraceful, the situation that we're in. You know, that we are rushing on very important things that everybody has already made, Deputy Carty and others, how important this issue was to the Justice Committee. And Minister, this should not be happening. Seriously, it is disgraceful. I have not seen a bill being pushed through with so many different things in it in this way at this time. You really should. You could have extended. I've been here for other debates that went on for much longer. I want to acknowledge the survivors that are in the gallery tonight, Hazel Bean and Paula Doyle and Sophie Brady. Hazel and Paula in particular have been campaigning on this telling the story does not do justice. They have actually campaigned in a real way in so many different forums. Paula, for example, was recognised by the Association of counsellors and psychotherapists. Hazel testified to the Justice Committee, but has campaigned, organised protests, organised photo stunts, press conferences and so on. And Sophie, I hope, doesn't mind me saying, Sophie hasn't attended therapy because this law exists. And that's shocking and that's disgraceful that a young woman can't avail of something because of how it might be used against her in trial. And people are having to choose between trial or therapy. And unfortunately, with the changes that you propose, Minister, that really still exists because the chilling effect is still there. I just also want to mention people who aren't here, and many have been here before and packed out the gallery, but Lisa Murray, another survivor who's done a huge amount of work on this, and in particular as well a therapist, Barbara Kelly, who sort of paved the way in raising this in the professional bodies as well, and therapists, psychologists, right to today, have made a statement that your changes don't go far enough, Minister, and that you haven't dealt with the issue at all. Now, there's 3 options in front of us tonight, but we don't really have adequate time to debate them. There's the Minister's option, there's a total ban, as advocated in my motion 20 and in another Sinn Féin motion. And then there's attempts by pretty much all of us to mitigate the damage that your proposal is still inflicting on complainants by asking you to do what you actually promised to do, which is to put in a presumption of non-disclosure written into the law to make it much stronger. All the survivors have asked for that, if you're not going to ban it totally. And then other things, that there should be warnings issued by judges, like therapy is not evidence, and these notes should have a massive health warning in any trial. So I just want to basically deal with some of the issues. Like, Minister, you were down launching the Dublin Rape Crisis Centre's annual report, which showed a massive increase in calls. All of the service organisations say the same. And They're people who have made contact, but there's so many people who don't report anything, who do not talk to anybody, but even then who don't pursue a legal case. And one of the reasons is because of this type of situation that's hostile, that's intimidating, that's re-traumatising, where their own personal thoughts can be used against them by the person who did the most horrific crime to them. And, you know, I think that there's no doubt about it. Character reference is another major problem. But nearly every survivor has come out from the court steps and named this as being something that should be changed. And so I would just reiterate a couple of things. In Tasmania, which obviously is a state in Australia, they actually do have a total ban where the complainant must give their consent. And that's another thing that you're removing, Minister, with your proposal. We all know there was a problem with the waiver, but you're taking away agency completely. You're taking away the right to say no to having your notes handed over, and you're passing it directly over to a judge. A judge, by the way, who is not trained in analysing therapy notes, in analysing how therapy works, the fluid way that it works, and the way that people potentially can even say things that could be seized upon. And you're also not introducing very high bars. I'll just run through some of the key things that your proposal doesn't deal with. So first of all, the explicit presumption of non-disclosure should have been written in. You do not require the accused to engage with the facts of the case at application stage. It's very loose, Minister, to have that it might be relevant to an issue in the case. You put in a real risk of an unfair trial, but then you water it down with this huge proposal, as has been said, of in the interests of justice, which any decent lawyer is going to argue exists. And you continue the violating practice of raw counselling records and notes being handed to teams of lawyers and the accused. You could have put, huge barriers in the way. You promised to do that, but it still isn't done. The system that you're bringing in seems to mirror the Canadian model, a system whereby there's a mandatory hearing for every single case, and that's currently being reformed due to the damage that it's been found to have done to survivors. I think it's worth mentioning, and it's just a statement of fact. I'm not going to comment on the trial because I obviously don't want to impinge on the outcome of it. But counselling notes have been used in the Donaldson trial in the North. And I really think that just speaks to how these notes are being used all of the time. I obviously can't say too much more about it. I don't want to in any way affect it. But how damaging that is for any complainant who might be a victim of child sexual abuse is just unbelievable. Minister, I think that you say that, sorry, I'll finish on this, a total ban isn't possible. I think there's other contending rights. But let's look at having a referendum in this country then, because we can't continue to have a system which traumatises survivors.
Deputy Butterley.
Minister, like everybody else in this House, I would have loved to have had plenty of time to speak to my amendment, which is number 20. Out of respect to Deputy Gannon, who I presume is going to want to speak on this, I'm going to be quite brief and try and contain myself to 2 minutes. Minister, Amendment 20 reflects very much Deputy Kelly's amendment, which was also reflective of my thoughts on this, on counselling notes right from the very outset. It also reflects the Dublin Rape Crisis Centre, and it essentially is looking for a halfway house on what you have proposed and what we would like to see. We have accepted that a total ban on counselling notes is not possible, but we're asking, we're urging, we're pleading with you, please reconsider. Let's have a look at it again. Let's have amendments brought to the Seanad where we will have an express presumption of non-disclosure. We cannot continue to put the women through this again and again and again. The standard, the bar, must be very high. If we don't have this, we are just going to go round in circles again and again and again. And we will be arguing, like lawyers do, on the head of a pin. And we will find ways, if it's not express, if it's not clear, and if it's not unambiguous, we will find ways to work our way around this. So it has to have an express presumption of non-disclosure. If not, all we'll have is a flood of applications coming into the courts, which will clog the system, it'll be costly to the system, and ultimately it'll have no regard for the alleged victims. Secondly, I'd like you to also consider what we consider to be the relevant tests for this. Yes, necessity, yes, probative values, but most importantly, no judge should issue a disclosure order unless he believes or she believes that there is a real risk of an unfair trial for disclosure. I'm rushing through this, I'm galloping because I'm very conscious of time, but I would like you to take Amendment 20 in its entirety. It also talks about a timeline after the Book of Evidence, that these applications happen at the beginning of the process, not nearly towards the end or prior to a day or two before a trial begins. So I'd like you to look at that. I would also like you to include the District Court when considering the courts that can have the applications. Thank you, Minister.
This is an issue of such importance that I'm going to concede my time, if it's okay with you, that we can have a vote on this particular issue. And I think that might require you to, I think there's a lot of conversation rightfully to be had, but it might require yourself to just allow the vote to happen. I think that's fair, Minister.
You do have an opportunity to tell them which
Sorry,
one.
what are you saying to me, that I shouldn't speak for too long? To allow
Just allow the vote to happen, because once...
What can I give 2 minutes?
That's up to you.
The first thing I want to say is I want to say I've listened to people in the House and I acknowledge the presence of survivors in the gallery, and I commend them, because the reason why the law is being changed is because of the advocacy of campaigners. I think we all agree on one thing: the current situation is unacceptable. The current statutory scheme that operates is unacceptable. It needs to be changed. It needs to be changed in order to weigh the balance between fair trial and the right to privacy more in favour of the right to privacy. I believe that is what I am doing. I cannot ban counselling notes. I simply cannot do that because of the legal advice that I have received. The Labour Party recognise that, like people in this House recognise that. In terms of the proposal from the Dublin Rape Crisis Centre, I gave consideration to it. I've prepared a response in respect of it. I just want you to know that that scheme is not that different from what I am operating, except that they will have a panel of barristers deciding it as opposed to a judge. And just finally, on the interest of justice, the reason why I left it in is because the advice I received is that counselling notes can be very beneficial to the prosecution of sexual offences and rapes. They corroborate what a complainant is saying, and they are very beneficial in terms of getting people convicted, because the counselling notes confirm what the complainant is saying. And that's why I have left them in, and the advice I have received is they have been of assistance in achieving convictions, because I'm conscious what Deputy Gannon said, and I want to allow a vote.
No, you're finished. You don't want to respond. Yeah. Well, the difference is I have to ask the question first. Okay, so the amendment be made. Is that agreed?
Not agreed.
Not agreed. Deputies in favour say Thaw. Deputies against say Neil.
Neil.
Question. Would you give me a chance for the record? The question is lost. Vote on. 10-minute bells, deputies. Please We have a lot to do. I'd ask you to take your seats. Criminal Law, Civil Law and Defence Miscellaneous Provisions Bill 2026. Report stage amendment number 17 in the name of Alan Kelly. The question is that the amendment be made, and on that question a division has been challenged. Deputies Thaw, Alan Kelly and Ruth Coppinger. Deputies Neil, Mary Butler and Emer Curry. Thorough result, Deputies Thaw 68, Deputies Neil 78. The question is lost. If you bear with me now, we have a further question. Because the time permitted for this debate having expired, I'm now required to put the following question in accordance with an order of the Dáil of the 9th of June. That Amendment number 30 and the amendment set down by the Minister for Justice, Home Affairs and Migration and not disposed of, including those in respect of which recommittal would in the normal course be required, are hereby made to the bill. The fourth stage is hereby completed and the bill is hereby passed. Is that agreed? Not agreed. Deputies in favour say Thaw. No. Deputies against say Neil. The question is carried. Vote all. Short bells 2 and 1, deputies. Thank you, members. The Criminal Law, Civil Law and Defence Miscellaneous Provisions Bill 2026, fourth and fifth stages. The question is that Amendment number 30 and the amendment set down by the Minister for Justice, Home Affairs and Migration and not disposed of, including those in respect of which committal would, in the normal course, be required, are hereby made to the bill. Fourth stage is hereby completed and the bill is hereby passed. And on that question, a division has been challenged. Deputies Thaw, Mary Butler and Emer Curry. Deputies Neil Porrick McLaughlin and Matt Carty. Deputies Thaw 102, Deputies Neil 45. The question is carried. The bill will now be sent to the Shannon